So, ma'am, can we start?
Yes. How many participants do we have as of now?
Ma'am, nearly about, let me check once, ma'am. Ma'am, 50 of them are joined now.
Okay. Okay. I think we can wait a minute more and start.
Okay, ma'am, sure, ma'am. At 5, we shall be starting.
Yes.
Okay, ma'am.
Are we good to start, Vidya?
Okay, ma'am.
Yeah.
I hope you can see and hear me well.
Yes.
Okay, ma'am. Good evening and a warm welcome to all the attendees. I am Vidya Bharti, a final year BLLB student of Amity University, Chhattisgarh. I will be the facilitator for today's session organized by IURIS JURA. Thank you for joining us. IURIS JURA is an organization that always helps you to get you benefited in the best possible way in legal learning and to create legal awareness all along and to showcase your hidden talents through various events. Today, we are connected in this virtual platform to gain a better insight towards the legal perspective on GDPR and data privacy laws. GDPR stands for General Data Protection Regulation. It's the core of Europe's digital privacy legislation. At its core, GDPR is a new set of rules designed to give European Union citizens more control over their personal data. The reforms are designed to reflect the world we are living in now and brings laws and obligations, including those around personal data, privacy and consent across Europe up to speed for the internet connected ages. So, for a better understanding and to learn further integrity, we are here. For this, we have our respected guest among us who, with her knowledge and insight, certainly would be able to provide a much better insight to us. I warmly welcome Miss Snidha Mehra, ma'am. Ma'am, we are highly delighted to have you with us. Now, I want to take an opportunity to introduce her to all of you. Snidha Mehra, ma'am, has completed her LLB honors from New Law College, Bharati Vidyapit, University, Pune. A legal professional with over 6 years of experience with a license to practice as a lawyer from Bar Council of India since 2015. Snidha ma'am was a practicing lawyer at the Supreme Court of India and Delhi High Court, along with other forums across India. She was an attorney for the Government of India and several public sector undertakings, such as National Highway Authority of India, Container Corporation of India, Steel Authority of India, Dedicated Freight Corridor Corporation India Limited, HMT Watches, CBI, and Airport Authority of India, to name a few. Thank you for joining us today. Welcoming you, ma'am.
Thank you. Thank you, Brinda. Thank you so much. And thank you, everybody, for joining this session. So, like Brinda gave an overview of what exactly are we going to be discussing.
Ma'am, yes, ma'am. I will just tell the chronology the way we will be discussing, then you can carry on.
Okay.
So now let's start for what we are here. Let's hear from our eminent speaker about the topic very minutely. Just a little housekeeping before moving further. I would like to focus on the chronology of the fruitful session. This session is divided into three segments. Firstly, ma'am will be discussing in detail about the GDPR and data privacy law. Secondly, there will be a question answer session in the last 10 minutes. If you have any kind of question during the session, then I will let you get your answers during the question and answer session. Kindly attend the session throughout and kindly cooperate with us. Lastly, we will be wrapping up today's session through vote of thanks. Now, without further ado, let's get started over the session, and it's over to you, ma'am. Please, ma'am.
Okay, thanks, Brinda. Thank you so much. And thank you, everybody. And it's a pleasure to be conducting this session with all of you. And a warm welcome to everyone. Brinda, I hope there is no echo during the session.
No, ma'am.
Okay, okay. Thank you so much. Okay, so the intention behind this entire session is to acquaint all of you with the much talked about and the very recent General Data Protection Regulation, which has been enacted in the European Union. But the same has an impact not only in the European Union, but across the world. Across every country, it will be applicable in India as well to companies in UAE, to companies in Singapore. It has a pan global effect. And this regulation is basically deemed to be a base regulation for almost all jurisdictions to base their data protection regulations. Recently, also, being it UAE, be it Saudi Arabia, be it India, that's also still in the pipeline of enacting their personal data protection law, have been basing their entire laws on GDPR. So, this session will basically help you to understand what is the data protection regulations that are being practiced all over the world, as well as some of the data protection regulations in UAE, in India, and how and why is it now important as us as individuals to understand our rights under these data protection laws, as well as lawyers to understand how we should be advising our clients, be it corporates, be it individuals, if there is any kind of data protection breach. So nowadays, all of us know that all kinds of businesses have taken a drastic change in the way they function, their market. Of course, post the pandemic, we all have witnessed that e-commerce, e-business has really picked up, which means that a lot of data of us individuals, are being processed by companies without our knowledge, without our consent, without us knowing what are they exactly doing with this data, how are they storing it, how are they processing it, for how long are they keeping it, are they going to delete it, are they sharing it with any third party, with any other agencies that we have not consented to. So these are the certain concerns because of which the lawmakers have now enacted the General Data Protection Regulation in the European Union, but of course with an effect pan global, with people who are companies who are processing specifically in India, in other countries, of the data of the people who are there sitting in the European Union. Companies nowadays have a lot of data of every customer, be it the name, be it our phone number, be it our bank details, be it our credit card numbers, our age, our weight, height. Any detail that can attribute back to us is right now available with a number of companies, and they process it on a daily basis through their marketing agencies, through their in-house marketings, to understand our behavior, to target us as audience, and to advertise accordingly. So we definitely need to be careful while we are putting our details on any kind of websites where we are putting for any inquiry, or for that matter, anybody, a customer service agent, asks for our data. We have not been conscious, we have not been aware of any of our right that we have, that while we're giving these details, we need to ask them of, do you have a consent to process it? What are you going to do with this data? Are you going to store it, use it with someone else? Do you have any kind of guidelines while you're transferring the data to a third person? No, right. None of us has ever thought about these questions. And that's the reason why these regulations have now been brought into place, so that we as data subjects, we as individuals, understand how and why is it important for us to know these regulations, so that if there is any kind of breach, we understand what kind of rights and remedies we can take against those who have breached our data, because of whose negligence our data has been breached. And definitely it's something very important for companies as well. We as lawyers do need to advise the companies that we are working with, that why is it important to be compliant with these data protection regulations. Why is it necessary that today everybody needs to make sure that they have proper checks and balances in their companies, so that the data that they've been procuring from their customers, it's not breached, it's not leaked. It's very important as an individual, of course, to know our right, but as a company to be compliant with them, because that is how you will gain confidence. I'm sure all of you must be hearing a lot about the recent cases about how Facebook has been fined millions and millions of dollars, how Marriott has been fined millions and millions of dollars. Few case studies that I will take you through by not being compliant. Companies as big as those have not been compliant and have faced penalties from the regulators time and again. And of course, you need to gain some kind of confidence from your customers in order to remain in business for a long period of time. The PDP bill, like everybody knows, is there in the parliament, and is also on the similar lines of the General Data Protection Regulation. Our parliament, the committee, has been time and again contemplating on the changes, bringing it in alignment with GDPR, because that is the base regulation that has been treated with and taken care of by most of the countries. And we hope that soon even India sees the light of a sound data protection bill, which shall definitely, as Indian citizens, for us, be very beneficial, and will definitely, in case of any breach, help us to get some kind of justice, or, of course, accountability towards the companies who at the moment are storing our data. So, to move forward, I will be taking you through the general overview of what and why were these data protection regulations enacted. What is the scope of application? Of course, everybody must be thinking that why the general data protection regulation in European Union is important for us. So I'll be telling you about the same. What exactly constitutes some of personal data? What is personal data? What comes under the ambit of that? And there are certain concepts which are key to understanding the general data protection regulation, and for that matter, any data protection regulation. So, those are some key definitions that I'll be taking you through. There are certain principles. Now, this is something very important. While we are going through this session, we'll understand why and in what manner can companies process our data, and of course, what are our rights, what are their obligations, what are their duties, that I'll be taking through in this. Then there are certain other concepts which are new, and which companies definitely need to have inbuilt in order to protect our data. And of course, certain designations, certain people they need to appoint, so that in case there is some kind of a breach, we as customers, we as individuals know who we are supposed to report to, or ask for some kind of a remedial measure. Then, of course, breach. What happens if there is a data breach? What are the consequences on the companies? How can we as individuals go and approach and have agreements with redressal, for any kind of complaint that we have? And of course, what kind of codes and certifications generally that companies need to undertake in order to be compliant with the general data protection regulation. So generally, these regulations are individual friendly, but definitely they are enacted so that they become business friendly as well, also, so that there is free flow of data between jurisdictions. It becomes easier for individuals, for companies, when data is being stored not only for that matter somewhere in India, but somewhere even if in Europe, and is being processed in India. So that's the reason why these regulations have some stricter regimes, but have given mechanisms as well, so that there can be a free flow of data. So they have a comprehensive set of expectations of how a business should run, of what all a business should take care while they are processing the data of everybody. Obviously, the main and only concern of these regulations is to safeguard the individual's data from being misused. They need to make sure that they have proper checks and balances while they are processing our data. Otherwise, that will cast a heavy penalty on them. They will be accountable, and the penalties are high at our basis on turnovers. So, for example, if there is a big company and they have a turnover of more than 500 million, their penalty will be calculated for any kind of infringement based on their turnover. It might be 2%, it might be 4%. That's something that we will be studying later. But this is the reason why these data protection regulations are enacted. And this is the reason why every company needs to make sure, in order to not have a bigger penalty on them, which will be definitely a financial burden. Now, of course, the scope. Everybody, all of you must be thinking, why is GDPR important? Why are data protection regulations important? So, the GDPR under Article 3 of the regulation clearly stipulates that it is not only applicable to European Union companies, but it is applicable to the non European companies as well, which means that if a company sitting in India is processing any kind of data of any individual who is a European Union citizen or a European Union resident, they will have to comply with the entire ambit of GDPR. And not only GDPR, there are other regulations also, other jurisdictions also that have enacted the data protection regulation of their jurisdiction, which encast upon any other company, say, suppose sitting in India, or who are processing their data, their country's data, to be compliant with data protection regulations. So, in order to be compliant with all sets of data protection regulations pan global, it's always advised to a company that from the inception they have a data protection regulation regime, which they know from the beginning how are they supposed to comply with it, what are they supposed to do, what are the checks and balances, so that in order to, if there is a breach, say, of data of if an X country, there might be not only violating the regulations of that country but of another country as well. So they need to be very careful while they're doing it. So even if India at the moment does not have the PDP Act in place, it's advisable for big companies, so that there is some kind of checks and balances. And when the PDP is enacted, at that point of time, they do not face any kind of issues or any kind of problem, and they're ready to implement that act sooner or later. So this is basically the scope of GDPR. So any persons whose data is being processed by an Indian company being in the European Union, they will have to comply with all the regulations. Now, what is exactly personal data? Personal data is anything that attributes back to us as an individual, like you, me, anybody, everybody attending this webinar is a data subject. Our name, our date of birth, our address, our phone numbers, email IDs, photographs, identification numbers, everything is a part of our personal data. Our biometrics, everything that's been secured and saved by any kind of authority, by any kind of company, is our personal data. And there is a special category of data which generally most of the general of the data protection laws do not allow to process until and unless you have a valid reason. So, for example, your religion, your ethnicity, your sexual orientation, your medical informations, your trade union memberships, all of them form a part of your special category of the personal data. And generally, without any specific reason, without any legitimate reason, no company can, or no authority can process this data until unless it's a law enforcement agency like CBI, ED. They definitely will be getting exemptions under the data protection regulations, because, of course, in the interest of the nation, they will definitely have the right to process our personal data. But any other authority, any other company, unless any explicit consent is given by us, or there is any court order or other legitimate expectations, they will not be able to process a special category data. And of course, for the personal data also, they will have to make sure that they comply with whatever the law and regulation of their country stipulates. Now, moving forward. Now, these are three main key elements and key definitions under the GDPR. So, data subject, as I said, it's us, it's any individual is the data subject. If you come to controller, now controller is the person who exactly has your data, who is processing your data. It's probably on their website, on their forms, while you enter a coffee shop, anywhere they will ask you your phone number, your email ID, your date of birth. So anybody who takes your data firsthand is known as the controller. He is the one who will be responsible if there is any kind of breach, if there is any violation of the regulations. They are going to be the one that are going to be held responsible. Now, the second concept is a processor. Processor is the one who basically, on the behalf of the controller, he is the one who processes the data. So there could be a possibility if there is a company, and in the company there is an HR department. Now, at times the HR department has a lot of data of their employees to manage, but at times they outsource that to a third party. Now, that third party is the processor to whom they have outsourced it. So, like a controller, the processor is also under an obligation, but their obligation is towards the controller. They need to make sure that whatever are the liabilities and whatever the regulations are imposed on the controller, the processor also abide by the same. But all of this, the controller needs to make sure that the processor is abiding by. The controller needs to give the processor timely instructions. They need to get into a formal, proper contract. A data privacy contract, a data management contract is something that they will have to enter into, where all the checks and balances, all in case if there is any kind of breach, what will be the liability of the processor and how he's going to be processing the data. Each and every movement of the processor needs to be written down in black and white in that contract. And the controller from time to time can definitely check how the processor is processing the data, can ask for any kind of documentation, any kind of technology they are using. So controller will always have the right over any process of the processor, because of the reason that processor is processing the data on behalf of the controller. The processor is not the owner of the data, the controller is. But for the purposes of a regulator, of course, anytime any breach, it is going to be the controller alone. And how do you decide if a person is a controller or a processor? It's by a simple test. The test is, if the controller is the person who actually decides on how the data is going to be processed. And processor is simply a person who follows the instruction of the controller. If suppose there is a situation that there are two companies and both the companies together jointly decide of how the data is going to be processed, they become a joint controller, because here the other party who is probably processing the data is taking a decision with regard a decision on how the data is going to be processed. And if that's the situation, then you come under the ambit of becoming a joint controller, and a joint controller will be equally liable in the front of any regulator like the controller would be. So this way, yes, the processor has a little cushion, but if you are under a contractual liability, even if controller is being penalized by any department, the controller can obviously, under its contractual obligations, claim that damages from the processor. So, as a controller and processor, you both need to be careful while you're vetting your documents, while you're undertaking responsibility of processing data. Now, there are the some key seven principles that while you're processing data, it needs to be followed. You need to make sure that you abide by this. And this is enlisted in Article 5 of the GDPR. So basically, you need to make sure that your data that you've been processing is lawfully processed, it's fairly processed, and and then there is transparency with your individual of how you're going to be processing that data. Lawfulness is something which has further ingredients, which I'll be taking up in the next slide. Fairness exactly means everybody knows that there is a process of automation. Now, automation exactly means that supposedly I am filling up for a loan online. I have put in my credentials online, all my details, my bank account details, my salary, my name, my where I belong to, and based on that detail, the loan agency, without even having a word with me, at times shows that your loan has been rejected or is being processed. That entire exercise is known as automation. So if you are processing any data which is through an automated way, you need to make sure, because we as individuals don't know the criteria on which they're rejecting our entire data or they're accepting our data. Why are they getting to a conclusion or getting to a decision? So for that reason, every regulation stipulates that in case of automation and any kind of data being processed in such a manner, the data processor, the controller, needs to process it in fairly, in a fair manner. There should be no bias in that kind of a situation. Transparency, very important. Right now, there is no transparency on how our data is being processed. We put it on a website, our email ID, our phone number, probably just to get some kind of an idea of what kind of a product or services a company is providing. But have we ever realized that in the company's policy or in the company's any kind of manual or disclaimer to us, have they mentioned that what are they going to do with this data? Probably you would not want to go ahead with any kind of product that they are supplying to you. You would not want any services from their side, but your data is still with them. You don't know what is going to happen. They might give it to some other company. And I'm sure all of you must have faced this, that you're scrolling something on Facebook, you're seeing something on Facebook, and the next minute a similar advertisement is pops up on your Instagram or pops up on your Google. So, has any one of us ever thought of why is this happening? It's because these big companies have our data stored. They are changing hands of our data without us knowing about it, without us being informed that this is something that they are doing. And we all have been very ignorant about this, because definitely we will say that yes, there is no law as such in our country. But of course, sooner or later there will be a law. There are laws in other countries also. So definitely it's our data. We should and we can hold companies accountable for the same. And it's going to be for the benefit of the company if they have certain checks and balances in order. Like I said, they will be penalized if there is a regulation, if there is a law and they infringe it. They will have heavy penalties, which will definitely might get some companies into financial crisis also. Like somebody like Facebook, Google, big companies like Marriott will be able to sustain that. But any company that's a startup or just began its operations and is doing well and gets into some kind of a data protection infringement suit or any kind of a complaint, their entire credibility will go down. Their entire whatever customer knowledge and whatever confidence that they have gained, that all they will suffer big time. Purpose limitation. This is important. You need to take the data as much as you want. The data which is not required should not be processed. It's very important for data minimization and for purpose limitation. It's always necessary that if you don't need the height, if you don't need the address, if you don't need the age of the person, you should not store such data which is not helpful for your processing. That is not legitimate. That is something that you're doing. Sorry, that is not legitimate. And of course, there needs to be accuracy. There needs to be accuracy in data, and you need to make sure that whatever data you are storing, that data needs to be accurate. It needs to be kept properly stored. It needs to be encrypted. Now, that is something for the IT departments of each company to see, but there needs to be some kind of an encryption in the data. Then storage limitation also is the time till which you store the data. The data should not be stored for more than, say, an year. And if it's stored for more than 1 year, there should be some kind of a legitimate answer to that, that, why are you keeping such a data in your archives? For example, yes, an hospital will say that yes, we will keep the data for 10 to 20 years because the patient might come back again at any point of time. That's a legitimate answer. But say, for example, a cakery or a bakery, they are taking and storing your data. They would not probably need it after 1.5 year, because the expectation that a person might come back, might not come back, is little less in that situations. Of course, confidentiality, the entire premises of this law is to protect the data. And this is some kind of a moral obligation that a company needs to take upon themselves, that they need to make sure that, there is no breach because of any kind of a discipline that they have not maintained while processing the data. And accountability, of course, for sure. Every data processor, every data controller is accountable for the data that they keep. Now, moving forward, these are the few legal grounds that, while processing any data, every company and us as individuals need to understand that these are the legal grounds on the basis of which our data can be processed. Anything outside these obligations, we have the right to object. We have the right to say, no, our data should not be processed. So the biggest and the foremost is data subjects consent. Now, we have never given consent expressly for processing any kind of data. Have we? I don't think so. Any of us have. We go to a shop, they ask our phone number, we give it to them. They ask our email ID, we give it to them without even thinking that, exactly, did we ask them what are you going to do with it? Where is it going? Are you going to be giving it to any third party or not? The entire premises is consent, and the consent should be explicit. It should be unambiguous, because right now there's an ambiguity, because it's just that they give it to us, and it's not their fault. Also, it's our fault, because as individuals we have never thought about this. We have never thought, oh, it's necessary, okay, let them take it. But have we thought of what happens to our data? Impersonations are happening at a rampant speed right now. Are There have been bank frauds. It's why because without even thinking twice, we put in our credit card details, our CVV numbers on any website, without even checking their policy of how they're going to be storing our credit card details, our CVV number. Do they have a proper mechanism in order? Do they have a proper check in order in case what happens if there's a breach? And it happens. It happens because of us putting our details on these websites. It's very easy for hackers to get in catch hold of these data and impersonate us, and clone our cards, embezzle money out of our accounts. It's only because as data subjects we are not cautious, and companies do not know what are their obligations. Then we have performance of a contract. If there is any performance under a contract, if you're obligated to process some kind of data, that becomes a legal count. Public interest, official authority, yes, like I previously mentioned, any government agency, any lawmaking agency, enforcement agencies, they of course have the right to process our data as and when. And for them, of course, we that is something where even consent is exempted. So there is something for the nation's interest, for our security. There we will not be able to enforce any kind of data protection regulations for our protection. any kind of vital interest of a person, any person to basically safeguard the life of a person, or while if some calamity happens or anything. So the public interest and vital interest of a person is generally two legal grounds given to law enforcement agencies. And of course, if you're under any legal obligation, if you have any court order or anything of those sorts, then you can process data legally. Then finally, you come to legitimate interest of the controller. If you can prove that you have a legitimate interest in processing this data, then also you can go ahead with it. But the reason needs to be viable. And that also will not absolve you of your duty of protecting the data. Now, the rights of data subject. We have more than 8 rights that all of us need to be aware of while our data is being processed. So, the first and foremost, we have the right to be informed. We have the right to be informed of where is our data being stored, for how long is our data being stored, is it going to be shared with another person or not. All of this information, like consent, we need to be informed at the time they're taking our data. And it's not possible for the company to do it on an individual to individual basis. It's generally there, it should be there in their policies that they upload online. And for that, as a prudent customer, as a prudent individual, it's our duty to check the policy before we put in our details on with any company. We need to see whether or not are they complying with everything. What happens if tomorrow there is some kind of a breach and I find that, oh, I didn't give this company my data, how does this data have my company, this company have my data? So do I know, oh, I put my credentials on this website, it looks similar, it's probably the same company. Can I go and can I speak to someone there? Can I put a grievance there? So that is something for you to check before giving your data, of whether there is any kind of mechanism where you can reach out to a specific person, inform the company that yes, I did give you my data, but I did not consent for a third party. I did not consent for giving it to anybody else. I did not consent it to be processed as the format. So this is something you need to be informed as an individual. Access, of course, it's the company's duty to provide you access of your data at any point of time. You have the right to understand and to know where exactly your data is, and which part of or which person exactly is processing your data, who is the person, which department has control of your data. Then we have erasure. Erasure is simple, very clear. If you do not want your data to be processed by that company any further, you can write to them. You can tell them that no, you cannot keep my data with you anymore. Your systems cannot, your servers cannot have my data, and you need to delete the data immediately. This is something that generally we there is a concept known as a data protection officer. It's every company needs to have that, and any person who's aggrieved by any kind of infringement can approach a DPO, write to the DPO directly saying that this is my details. I've come to know that this has happened with it, and I want the data deleted from your systems. Then restrict processing. It means at a time if you are giving your data to somebody, but you do not want them to process it further. You don't want an erasure, that is up to you. But you can tell them, okay, you are restricting the processing as of now. You do not want it as of now to be processed. Maybe later in the day, it's fine with you. Then you have data portability. As a matter of fact, as a right, you can ask your data to be transferred to any other service provider, to any other company by the data subject. For example, for a loan application in European Union, if you do not want it to be processed by an X company, you can definitely approach a Y company and say, okay, this X company will be transferring the data to me, to the Y company. So this is definitely a new concept that has come. It is going to take time for companies to accept it, to have it as an inbuilt mechanism. But this is also one of the rights that are coming in the future up for us. Then object. If you come across that any website or any company is processing your data without your knowledge, without your consent, you can object to it. That how did you get this data? I never wanted you to process this data. So this is also something, a right to object that we have. Rectification, if we know that our data is being stored wrongly, we have the right to tell them that okay, yeah, my age is stored wrongly, my name is stored wrongly. You cannot have, they cannot, like that's, it's a duty on them to have an accurate data. This is our right of rectification against that. We can go and tell them that, get this sorted, get this rectified. ADM and profiling. ADM and profiling is, as I told you, automated data processing is something which is done rampantly nowadays by companies without our knowledge, without us knowing. They have been monitoring our behavior. They have been monitoring how we have, what is our spending pattern, what is our buying capacity. You must be seeing there are target ads. There are the why and how do they do the target ads? It's because of our behavior that they can map and that they can monitor. They know that, oh, okay, I'm looking at this website, I've put in my details at this website, that might be my paying capacity. Okay, so the next pop-up that I will have will is of another company. It's why, because my data stored in one website is being shared by the other website where I never showed an interest, where I never showed that I want any kind of services or any kind of products from. Then you have data protection by design and by default. This is mandatory for the companies now under Article 25 of GDPR. Every company, like they have a department of HR, they have an IT, they have a finance, they from the very inception will need to have a data protection segment as well. And they will need to have policies, people responsible, precautions and safeguard right from the very beginning that they start their operations. Of course, the companies that have been old players, they, after the enactment of the laws, are given buffer periods, and they will be able to get data protection by design and default in their organization. But for new companies, it's of course advisable that, and of course it's mandated now, that they will have to have such kind of data protection by design and default from the very inception. Data protection impact assessment. Now, time and again, when you are processing data, you need to make sure that if there is any kind of high risk, or there is any kind of you can identify that there is something you cannot mitigate while you're processing that data, it's your duty to inform this to the authorities back in the European Union. And for that, companies who are not present in Europe but are in India, they will need to have a representative under Article 27 sitting in the European Union, informing and being a face of the company in front of the authorities, and letting them know that, okay, this is the data that we are processing. We think that this is at high risk. Do you think we can process it further or not? The authorities back there will look into the data and look into the entire process that you're planning to undertake, and give you some sort of a buffer of 10 to 15 days to try to mitigate and submit another report. If in case you cannot identify any kind of mitigation measures, then at that time they will tell you not to process the data. However, if you can get mitigation measures from the very beginning while you're processing high risk data, then it is advisable to always have that in place. And there are data audits that now happen, like we have a financial audit, we have an HR audit. Now we have data audits also timely, which companies should undertake, which companies should follow, probably annually or 6 months basis, or the companies that process heavy data, probably a quarterly basis, to understand that if there is no loophole, there is no breach. Because at times while they're processing data, they don't know what's happening at the back end. Probably some employee is leaking that information to a third party, and that the manager will not come to know until and unless there is probably a data protection impact assessment. There is some kind of an audit, some kind of a check that is happening. So this is something very important from a company perspective. Now, a DPO. A DPO is one of the key officers of any organization. Under Article 37 of the GDPR, every company is mandated to have a DPO. It's a proper designated person that will be responsible for monitoring and seeing that whether the data has been processed properly, it's not being processed. He will be the face in front of any authority. Any issue, if the customer or an authority faces with the company, the first point in contact will be a data protection officer. So you need to make sure that when a company appoints a data protection officer, that person has the right requisite experience, that person understands your organization. Generally, it should not be a person who's a key managerial person, because we cannot have a conflict of interest there. It needs to be, it's advisable to have an individual from the outside to be the DPO of the company, or anybody who's, of course, not in the board of directors or in the top management can become the DPO. And DPOs are the one who will be responsible for the impact assessments, for training the individuals and training the employees, sorry, in the organization, making them sensitive towards why is it important to protect the data of the individual that they are collecting, why to keep confidentiality, how to maintain all of that, how to flag off issues if they feel that okay, something wrong has happened. It's the duty of every employee to flag it off to a DPO, or that this has happened, and it's the DPO's job to start taking risk mitigating measures. Now, this is the main concern that every person has, that data is being breached left, right, and center all across the globe at the moment. So, what happens if there is a data breach? What are the steps that a controller or processor needs to take at that very minute? So, Article 33 of GDPR is something that has enlisted the entire procedure. So, in case you have a processor, the processor will have to notify the breach to the controller, and the notification of the data breach to the authority needs to go maximum within 72 hours to the authority, telling them that yes, there has been a data breach. And in the meantime, of course, within that 72 hours, it's the controller's duty to undertake mitigating measures and even inform the department that these are the mitigating measures that we have already taken, and this is the process that we are following. In case if there is a high risk and you're not being able to mitigate that, you need to inform the same to your data subjects also. You either by emails, by press release, by messages, SMSs, any mode, any format, you need to undertake, so that your data subject knows that okay, your pin has been probably compromised. You can change your card, you can destroy your card, you can get your card blocked. So these are the kind of steps you need to take in case there is a breach in any kind of data. Now, of course, this is the part where everybody needs to be very, very careful, and that's the reason why I've been saying time and again, you need to have a proper data protection regime. It's the penalties and the fines. So, Article 82 and Article 83 of the GDPR imposes heavy penalties, and like you can see, the penalty for a little minor offense is about 10 million euros and up to 2% of the annual global turnover. So, in case you've a company you've just picked up and there is a data privacy infringement from your side, you might be losing everything and you might just become insolvent or bankrupt that very minute, just because of a fine, because you were not diligent enough to take care of the data that you were processing. Then there is, for major infringements, you have 20 million euros and up to 4% of the annual global turnover. This is what are the penalties under the Data Protection Act regulation in the European Union. However, for every country, the fine is going to be similar or less. But yes, there is definitely going to be a heavy penalty. Right now, even in the PTP bill, they haven't quantified the amount of penalty, but pretty sure because it's going to be in sync with GDPR, they will definitely impose a heavy penalty on companies back in India as well. And if there are data infringements qua Indians, it will definitely bear a heavy penalty. Now, definitely, few of the cases that have been recently highlighted in after the onset of GDPR, Google, and of course, for everybody, it is surprising that how big companies are being fined of with millions and millions of dollars for data protection regulation. It's because these companies are the ones who, at the moment, are processing the maximum data. They have the data of everyone, you, me, anybody sitting even 13,000 kilometers away. They have their data. So, because of non disclosure of their sources, about a year and a half back, Google was fined about USD 56.6 million for a GDPR violation. Similarly, H&M was fined about 41 million dollars because of acquiring, personal and family details of their employees, including their religious beliefs, which they were not supposed to. So, like we said, like you need to only store data that is required. So, even small breaches, even if you think that this is insignificant now, but later on when it's flagged up with the authorities, it definitely takes a major toll and you are fined with a big amount. Marriott was, in fact, one of the most interesting cases up till now. So the breach in Marriott had started in somewhere in 2015. And of course, yes, the onset of general data protection regulation was 2018. So when the regulation kicked in and the authorities started doing their diligences on companies, then is when, for the first time in 18, the authorities came to know that there has been a data breach of personal information of customers for almost 3 years. Almost for 3 years, the Marriott servers were being breached, and Marriott did not know about it. So for that, they were fined about USD 23 million. Not only this, recently there has been a case where the Ireland Data Protection Commission has ordered almost of a penalty of more than 500 million on WhatsApp, which of course is yes an appeal, but that was because they were not transparent. They were not disclosing how the data has been stored, how what is the legitimate interest that they had in storing some kind of data. And for that, the Ireland Data Protection Commission has come upon heavy on WhatsApp. And despite they being in appeal, despite there being probably being litigating till the end, if it's proven that there has been some kind of an infringement of the data protection regulations, they will have to pay that penalty. And that penalty, yes, of course, $500 million is a heavy sum of penalty. Similarly, there was another case right now. TikTok, as we all know, very famous. The Irish department has been looking into their dealings as well. There has been inquiries set up on TikTok as well, and because they are processing the users' information that is below the age of 18 years, so there they do not have a legitimate interest. You cannot process the data of a minor without the consent of the parent. That is not permissible. So yes, now since it's been 3 years that GDPR has been enacted, the agencies are coming heavy upon companies. And in a similar fashion, it will definitely be once we have the Data Protection Act in place, once the other countries have the Data Protection Act in place, they will give a cooling period of 1 year or 2 years to enact those laws, but however, or implement them in your organization. But however, it's time for every company to get their act in order, their house in order, as well as, of course, of every individual to understand that please do not give your data on any kind of website if it's not needed, if there is no use of that data there. And you are putting your entire probably savings, life savings, if you're doing any kind of bank transactions or putting in your credit card details, you don't know what happens to you next minute. And of course, be aware customers, do read policies. All of us have a habit of, okay, accept and move ahead. All of us do that. So be little prudent, spend 2 minutes extra, but at least understand that is the policy in place or not. If there's an issue, can I go back to them or not? Because they will say that you have agreed to it. You have said you've clicked the agreed button, so now you cannot have a grievance with us. So it's for us also to be prudent while we are entering into any transaction or availing any kind of services. Now, there are certain code of conduct and certifications. This is basically for the companies. The companies, in order to prove that yes, they are compliant, they should undertake some kind of certifications from different agencies that certify that yes, they are data protection compliant. They are been complying with their regulations. So it's advisable to have certain kind of certifications. Code of conduct is something that generally trade associations, every trade association for that matter, like if you're advising any trade association as a lawyer or you're a part of any trade association, you can, as a matter of fact, give them advice that yes, you should have a single policy qua each industry. So, for example, for an automobile industry, you can have a set of code of conducts for data protection, which of course will help any new player that is entering your industry, and of course the current players as well, to align their entire mechanism. So it makes it very easy. So this is something that is not mandatory, but it is advisable under the law. And with this, we've come to the end of the session. I hope you all like the same, and now we're open for questions.
Thank you, ma'am. You really enlightened us regarding this topic, and it was quite informative. Now, the further session will be dealt by me. So, ma'am, if it pleases you, now can we move towards the question and answer session by taking up the questions?
Yeah, sure.
So, ma'am, the first question is, to which supervisory authority one should report as per the GDPR if in case the personal data breach has been done in a non-EU state?
Okay, so the General Data Protection Regulation in EU is the base, and based on that, every country has their own parallel data protection regulations also. So every country has a data protection authority and a supervisory authority in that, which under Article 77 will give you the information. And based on that, any person who is aggrieved can definitely go file a first complaint before the supervisory authority of that particular country. And if they're not satisfied, then they can definitely go for the court proceedings as well. They're not barred by to enter into any kind of a litigation or any availing any kind of judicial remedy. So basically, Article 77 and Article 78 are the ones that give you the right and the power to approach any kind of authority or department. So every country will have a designated data protection authority.
Thank you, ma'am. So the next question is, can data subjects request a copy of their personal data or transfer this data to another device, another service?
Yes. So under GDPR, definitely you can. There is portability, which is a right that you have. That's under Article between Article 12 to Article 16. Those are your rights, and you can definitely ask the service provider to transfer your data. But yes, of course, as of now, India does not have that, and the bill does not contemplate it. We are yet to see what exactly as a right we get under the Personal Data Protection Act, which is formulated in India. But for the European Union, for the Kingdom of Saudi Arabia, for UAE. In UAE also, there are jurisdictions that have specific laws here. So you definitely can request for portability.
Thank you, ma'am. Ma'am, so the next question is, what liabilities are there upon the state administration of countries like India, which is a non-EU, to protect us on this field?
See, so the state administration as such do not have any liability. The state administration, if yes, if they are right now processing any kind of data and they are not exempted as a law enforcement agency, then when the act is enacted, at that time we will have to see what are the exemptions given to these authorities. If not, then they will, then definitely we will can approach whatever authority is there against them. And as such, we as individuals will, of course, if any other company is infringing our data, we can go to whatever authority is set up in our country to report that okay, our data has been infringed. It's something that you need to take up, and then the authorities will, question the companies. They will be the ones that will call for the company's answers, and of course take proceedings ahead.
Thank you, ma'am. Ma'am, that's all the question we have.
Okay,
So,
great.
moving further, we are heartily thankful to our speaker as well as the participants for having such a wonderful interactive session. It was very informative. Ma'am, you really enlightened us through your knowledgeable words and thoughts. It was a great pleasure hearing from you. And this session will surely be a strength for our viewers in the field of GDPR and data privacy laws. Now that we have came to the end of this session, I would like to continue with the vote of thanks. Respected dignitary and all the participants, I, on behalf of IURIS JURA team, extend a hearty vote of thanks to the honorable speaker who blessed her with her presence and took out valuable time from her busy schedule. Thank you so much to our esteemed speaker for sharing her knowledge and enlightening each of us through her words of wisdom. It's a great pleasure to listen from you, Ms. Snidha Mehra ma'am, on this topic. Our team shall look forward to having more sessions like that with you. Thank you, ma'am.
Thank you so much. Thank you. And it was a pleasure being on this platform. And thank you, Iris Juris, for this. And all the best to everyone. Thank you.
Thank you, ma'am. I must mention our deep sense of appreciation for the active participation of the participants, making it a successful one. Thank you to each one of you for your patience and your responses, as no program can become a successful one with a single person. So, lastly, I extend my big thanks to Eurishura team members for their support and contribution throughout. Once again, thanks to each one of you. Thank you. Thank you, ma'am.
Thank you.